Robinson, who represents Robinson.
May it please the court, on a limited basis, Your Honor, can I play?
I don't know what that means on a limited basis.
I'm not objecting myself on the terms of the jurisdiction of the court, but we will be here until there will be a challenge.
You have something that you filed and I'm about to put in place.
No, I haven't filed anything yet, Your Honor, because I just got started. Well, I'll be.
Yes. If you would know from the record that Mr. Coletti intends on filing the entry of appearance for him, that is now for Howard, who represents Howard. I believe I have the attorneys for Caputo and Tate. Is that correct?
Yes, Your
Okay. And why you all stand? I mean, what are you arguing to with? What are you arguing?
I believe that the argument was presented to the court that our support would extend the time on the TRO.
I have already ruled on that. So you've not had anything to say. And I ruled on that. We're not getting ready to have arguments on that. Okay, I made my ruling. Now, why else are you saying?
No other than Your Honor, I would like to raise that not an opportunity to respond to that.
I understand.
Yes, and I would like to object to the exhibits on the same grounds put forth by Mr. Porter on behalf of Mr. Howard and Mr. Campbell.
You think they're not authentic either with the parties?
It's a hearsay objection, Your Honor.
That's not what I asked you. I say, are you arguing that the parties that are in the exhibit are not authentic?
No, Your Honor. I haven't seen those documents.
Do you have a pardon on behalf of your client that is authentic?
I do indeed have a
Okay, well, let's have that. I'll take all the parties now that are authentic. Let me have what you have that you claim is not authentic.
The document will be here within another 5 minutes. I'm simply asking if I'm able to view the documents that are being submitted in reference to my client.
Ma'am, you can step back. Thank you. When you provide me what you believe to be a correct and authentic copy, and the court will allow me in. Right now, I don't have anything from you as well. You're here for a limited period. If you have an authentic document, I'll take that. But you say you don't have it. So, we'll move on.
Yes, ma'am.
And did you have any other motions other than to extend the hearing?
No, Your Honor, that will conclude the motions of the Attorney General.
Your Honor, I would like to court to address Mr. Brown.
Yes, sir.
Mr. Brown was served on the 18th of last week. I obtained on Friday night an appearance on Friday, and I filed motions today. I just want
Did you file them with the court?
Yeah, I believe we sent copies. I know I sent some emails to the court. I'm not sure that everything except the entry, I'm sure went to the court. I have an objection to the exhibit that was offered by the Attorney General's office referencing Ms. Brown. I don't have and don't wish to introduce any substitute for that. And the basis of which is that we have a 12-6 motion to dismiss with challenge the jurisdiction of the court with reference to Ms. Brown.
Do I have a copy of that?
I have copies. I've sent you copies, Your Honor. Admittedly, I just found them today, but I have copies I can give the court.
Yes, sir.
That I have petitions where the court was found and
Well, Councilman, you probably filed them. I'm not going to take them down and read them. We're in the middle of the hearing.
okay.
They're not timely at this time before the court, but I extent that you'll have all the opportunity in the world to file whatever you need to file.
Because I'm not, the reason I don't just reflect my objection to the entry of the exhibit by the district attorney's office.
The Attorney General.
I'm sorry. Attorney General's office.
Yes, sir. You claim that the pardon is not authentic as well.
Yeah, what I'm claiming is that this is just a evidentiary objection that we have. And
I asked you a simple question. Are you claiming that the pardon is not authentic?
My objection is that it's not properly before this court from an evidentiary standpoint. That's my only objection.
That's your objection, but that's not answering the court's question. Are you claiming that it's not authentic?
It's not authenticated properly before this court.
Thank you, counsel. Yes, ma'am.
And Your Honor, in light of the several objections with regard to the certified copy of the pardon, I know the court has already ruled on those objections.
Why are you going back to it?
I will not, Your Honor.
I'm beginning to wonder if you all practiced in court before.
I do have a new question, Your Honor.
Yes, ma'am.
With regard to defendant Osmond, was it the court's determination that a pickup order should be issued for Mr. Osmond?
Well, we don't issue pickup orders. We issue warrants for orders that have been violated by individuals. The question that I asked of the Attorney General was whether he had been served. But I don't get that anybody here is representing Ms. Osmond, so I won't discuss it any further. Generally, there's a contempt order that's issued in a warrant. But in light of your statements that he's not been served, I'm not sure at this point whether that's the appropriate action to take. And so right now I'm not addressing it.
Thank you, Your Honor.
Your Honor, have you heard previously about the order at which we exit the courtroom? The victim families are here. That may allow us to exit the courtroom prior to defendants and with
Now,
that.
this is a public courtroom. I'm not going to deal with that. The issue that we were addressing right now has nothing to do with victims or anything that the court can hear. And maybe that's what I need to lay down some guidelines so I won't have everybody running ragged, wasting their time in an attempt to sway this court's decision on this matter. It is a simple issue. The issue is whether the Constitution has been complied with. It is my understanding that the only persons that will be addressed will be persons that have been fully and completely pardoned. The hearing today was for those persons, if you read the order, to appear. And those persons and their attorneys should have appeared and provided this board with information that the individuals have complied with the Constitution. The Constitution can neither be changed by this board, cannot be changed by the Attorney General, and it cannot be changed by the legislature. If it is a constitutional issue, then it belongs to the people to change the Constitution. The only issue before this court is whether there has been compliance. I think it's without question to every attorney in here that has a license and is practicing that the government has the authority to pardon. The only issue before this court is whether the condition precedent with reference to felony conviction and the publication has been met. It doesn't change with which circuit judge hears the case. I would like to think that any circuit judge hearing it or any chancery judge hearing it would rule the same. It will not become a case about this judge or the jurisdiction. If you have briefs filed, do understand this court will read them. If it is consistent with the law, then certainly the court will abide by what the law requires to be the ruling. But there are people whose lives who are touched, the victims, the defendants who, for whatever reason, believe that their pardons are valid. But we're not going to drag this out for money in and not out and not have some decision with reference to where we should be moving in this case. There is a constitution that I'm duty bound to follow, and so is every other elected official in the state. I took the oath that the Constitution requires. I promise you, if I hadn't taken that oath, I couldn't sit on the stage. I'm going to extend this hearing for an additional 10 days, and because of the request of one of the defense counsel, I'll start it on Friday at 1 p.m. I would expect at that time, counsel, that any additional amendments as to individuals who were part that you have in question, that you make your amendments so that we don't piecemeal them, and that whatever presentation in terms of evidence can be made at that time. The court will listen at that time and allow the opportunity for the other individuals to present to the court, but it is should present. At this time, the court's injunction remains in place. The defendants have complied and showed up today. That had already been named, and that was Mr. Kern. Mr. Kern, if you will stand for me. Mr. Gatton, Mr. McRae, and Mr. Hooker. Your liberty is at risk. This court has allowed you to remain out as a result of the injunction and at the request of the Attorney General. This court had authority to pick you up and hold you until this hearing. But I trusted his representation that you could remain out and that they believe that if you were served, you would appear. I will allow them to remain out under those same conditions. Each of you needs to call the Department of Correction daily. You are not to leave the county unless you have gotten permission from this court. At that time, in counsel, I will listen to your motions and your concerns. I made my ruling with reference to whether this court is the proper judge to be here. It's not going to be about Judge Green. And that seems to be a regular media hoopla from time to time. It's going to be about whether the Constitution has been complied with. With that caveat, your clients will be able to remain out and to appear on the 3rd at 1 o'clock. And I trust that you will make that happen.
I will, Your Honor. One thing, my clients live in different counties in the state.
Yes, sir.
And they've been calling into those counties. Is that all? How they make
I think the order was said, and I don't think I'm mistaken, but I believe that the Attorney General was well aware of that, and we agreed that wherever they were, wherever the county was, that they could just make the call daily, and they would be in compliance, and I've not changed that.
One is out of state, present here today. That can remain that status quo?
That can remain, the status quo remains the same as with the initial injunction. As long as he complies and calls in and does not go beyond where the Department of Correction has allowed him to go, we have no problem.
Thank you, Your Honor.
The court has allowed, you may be seated, thank you, gentlemen. The court has allowed an amendment to add Aaron Brown. I believe that some persons were brought here, but their attorneys who represented Mr. Brown.
I represent Mr. Brown.
Thank you, counsel. Joshua Howard, you can remain standing. Mr. Kabulu, you represent him as well.
Yes, sir.
And Catherine Robinson. Yes, sir. And the final person was Kirby Tate. The status quo will remain for those individuals. If you need a ruling in order to tell the judges wherever you filed your writ of habeas corpus, my ruling is that any writ of habeas corpus filed before this court will not be heard until I have the hearing on February 3rd at 1 p.m. It behooves the other judges to rule as they deem fit if you filed in another court. I would expect that those individuals will appear on February the 3rd, those that are represented by counsel. If you wish the court to issue prosequendums for those persons to be brought into Hinds County, you will have to notify the court by properly filing the motion with the clerk, and the court will issue a prosequendum to transfer those individuals from the Department of Correction on that day. Is that understood? Yes, ma'am.
Sylvia Owen, Ohio, current case. My client is in a unique situation as compared to the other 10 persons who were pardoned between January 6th and January 10th, and that he is a non-violent offender and has
You're not arguing the matter. It's just going to stay the same.
I understand, Your Honor, and I would just like to say that the reason that was given for extending the TRO was that these people are a danger to society. My client did not have any victims, and he gave the proper notice, and we provided all of our proof to the Attorney General's office on January 11th.
Is your client incarcerated with MDOC?
Yes, ma'am. He is.
Under the conviction of a felony?
Yes, but he has been pardoned.
It will remain the status quo until February 3rd.
If I may, I'd like to lodge the same objections as the other attorneys regarding the evidentiary matter of the copy of the pardon. And in answer to your question, I do not challenge that the pardon is authentic. It is certainly authentic, but I am making the same objection on the basis of the evidentiary.
Thank you, counsel. Is there a problem with any of those things in terms of compliance?
Okay.
Thank you. We'll see you on the 30th.
Order in the court.
Sit down.
Yes,
Everybody
ma'am.
sit down.
And then I will.
I represent an individual that is not among those 10, and I'm not here.
Well, if you're not, that person's not a party. And I'm not addressing anyone's not a party. There's an amendment in the court grants the amendment to be properly reported.
Thank you for that.
Yes, sir.
The only other matter, Your Honor, is I filed a motion to disqualify the Office of the Attorney General from standing in on behalf of the state in this case, as the plaintiff in this case. And I think that motion is significant and important that it be heard by the court and decided by the court before we proceed with the preliminary injunction hearing on the 3rd. I'm sorry.
That's the one I read in the paper. They had an opportunity to hear it, but I hadn't or seen it or read it.
I've given that, unfortunately, I've given it to you today, Your Honor. That's one I emailed to the court administrator by mistake. I'm sorry about that. But
And what's the basis for requesting that the Attorney General be disqualified from raising a constitutional issue?
Judge, there are documents attached to that motion that would show that an employee lawyer of the Attorney General's office who was assigned by the Attorney General to represent the Department of Corrections or work for the Department of Corrections assumed the legal responsibility on behalf of the 4 men that I represent in this case who are present in the courtroom to publish their notices. And because of that is a conflict of interest for the Attorney General's office. Basically, it's a law firm situation. If that lawyer who was an assistant attorney general and still is, in representing the Department of Corrections, agreed to participate in the publication of the notices, then the Attorney General cannot now come to court and complain that the notices were not properly published if it was the Attorney General's office who assumed the legal responsibility to publish them in the first place. And there are emails, the text messages attached to that motion that would support that contention, Your Honor. And because of that, they have an unavoidable conflict of interest, and it violates the rules of professional responsibility for the Attorney General's office to prosecute this complaint against these 4 individuals, the 4 men that I represent.
Is there a response from the Attorney General in terms of that matter?
Yes,
Yes, sir.
And we would argue that this is just a thinly veiled attempt to try to divert the court's attention from what is a true matter, as Your Honor noted earlier, whether these publications were valid. The text messages that counsel opposite has pointed out do not support that the Special Assistant Attorney General has in any way undertaken to represent. There is no relationship. What Mr. Zorger is asking Your Honor to believe is that the inmates who are incarcerated at UDOC formed an attorney-client relationship with a lawyer that is assigned to represent the Mississippi Department of Corrections. That, as a matter of law, cannot happen. And even if it did happen, the imputed disqualification rules do not apply to government lawyers. This is not a law firm situation the way that counsel opposite described it. The comments to Rules 1.10 and 1.11 of the Rules of Professional Conduct make it crystal clear that imputed disqualification does not apply to government agencies. In fact, the Mississippi Supreme Court has held in the Lane versus Mississippi Public Service Commission that the Attorney General's duty is to do just what we're doing here, which is we often find ourselves in situations that are not proper in the private sector, but they are proper for government attorneys, and particularly attorneys with the Attorney General's office. And we would argue that this motion should be summarily denied. There is absolutely no merit to it. And the text messages, I would point out, that have been...
Counsel, let me read, and I'll read the text messages if they have any application. Again, my understanding of the issue is whether there has been constitutional compliance. To be honest, when the issue was first brought before the court, all sorts of things came across the court's mind, because I've said in cases where the issue of whether there was a mistake made, whether somebody didn't do what they were supposed to. The Constitution is clear, unambiguous. No pardon shall be granted until the applicant thereof shall publish for 30 days. The applicant. I'm not sure whether anybody in the Department of Correction can represent and agree to be the applicant or represent the applicant. But without that being said, or any arguments to the contrary, the Attorney General is authorized to raise any issues of constitutionality and whether the Constitution has been complied with, whether it is the governor, whether it is Judge Green, whether it is the legislature, or whether it is the Mississippi Supreme Court. I think that your motion is without merit, counsel, without seeing more. I will review it again tonight. But my ruling now is that the Attorney General has the authority, the responsibility, and the obligation to the people in the state of Mississippi to bring the action. I do not see the conflict that you argue for the court such that the Attorney General's office should be disqualified. My ruling at this time with reference to your motion is that he is not disqualified and is authorized to bring the motion for the petition for the injunction and to proceed further on the third. Anything else?
Please, Court General.
Yes, sir.
I represent former Governor Barbour, and I
Former
present.
Governor Barbour is not a party to this action. As such, I'm not going to entertain any intervention. I've not got a motion.
No, we delivered to your chambers on Friday, Your Honor, and it's
No,
not
sir.
to intervene. It's not a motion to intervene.
Who did you deliver it to?
Our Ronald delivered it. I'm above the snow, Your Honor. Our Ronald delivered it to y'all.
Counsel, I was here till 6 o'clock trying the case, waiting for a jury, and I don't have anything.
All I can do is represent to you what our Ronald told that they did, Your Honor, but I don't need them to impugn anybody's integrity. We're not here to intervene. I filed a motion for the court to allow us to appear for the purpose of filing a criminal court and to curate brief and to be heard on that. I'm not sure whether the Attorney General's office has objection. I'm not asking to be heard today.
Is it only on the issue of whether there was compliance compliance with the Constitution?
On that issue, in the law that relates to that issue, we're not trying to go outside of anything other than the issues that are before the court, including the law that relates to that. We're not asking to put on any proof, but the standard for being an amicus curiae is that the amicus has an interest in some other case involving some question. Counsel for a party is an adequate or agreed insufficient, or they are matter of fact or law which may otherwise escape the court's attention, or the amicus has a substantial legitimate interest that will likely be affected by the outcome of the case. In this situation, there are issues that are not being briefed by the parties because they do not relate to the substantial interest that former Governor Barbour has.
What is that substantial interest, counsel?
The issue of constitutional interpretation, in this case, is certain to have enormous and long-lasting effects on the power of the office of the governor of Mississippi. The current governor of Mississippi is not a party to this case. The issue will affect not only the former, current, and future holders of the office of governor, but also directly implicates the constitutional liberty interest of not only the main defendants here, but those of current and future recipients of gubernatorial clemency. The man whose power was used when he was governor to grant these pardons ought to be heard, and that's all we're asking. The court allowed us an opportunity as amicus to file an amicus brief and to be heard at the appropriate time. I don't know that there's any objection. If there is, I'm not aware of it, but we're not asking.
I'll take it up and down side of the council.
Thank you.
Anything else?
There is one other matter, Your Honor.
Yes, sir.
On my motion to disqualify, I understand, of course, that you're going to review the motion, the documents attached to it. But I do want to point out that what would probably be an obvious problem if we all had name tags on it, the representative for the Department of Corrections assigned to the Department of Corrections by the Attorney General is sitting at the council table with me, and that's Mr. David Scott. And he is the person whose text messages are attached to my motion, and he's now charged with representing the Department of Corrections, who's the named defendant in this case. And so he's working for the plaintiff directly. He's representing one of the named defendants in this case and sitting at the defense counsel table. And he allegedly, from our perspective, gave advice or entered into some kind of relationship with the four of the named defendants. So the appearance of impropriety here under these circumstances is quite significant, Your Honor. And in addition,
significant how, counsel? I mean, I've had defendants sitting at the same table who had differences of interest. It's not where you're posing. You don't have a jury. You have me.
I understand.
Okay, so what is your legitimate reason for telling me that you're sitting at counsel table?
He's supposed to make arguments for a defendant against his employer. And his employer's sitting there looking at it while we're in the courtroom. I think that's a problem, Your Honor. In addition, he's a material witness, and he's been subpoenaed as a material witness in this case. So he's going to be an adversarial party in this case, and he's going to be a witness in this case.
No, that's what you're saying. That's what you're saying, counsel. I make the decision of who I hear from. But don't make an argument that he is. He's someone you have subpoenaed. But it may not be that he's a witness in the case. He can sit at defense table. He is a defendant in this case. But in terms of anything else, I'm not going to tell him he can't sit at defense table. Yes, sir, Mr. Scott, you said.
I would like the record to be clear that I have not been subpoenaed in this case. I know counsel has indicated that.
Yes, sir.
And if the court would like to dismiss the Department of Corrections as a defendant, I would be happy to do myself.
It's my understanding that maybe now, a few weeks that I served for 7 years in the legislature, I've been here long enough to know that the attorneys in the Ayers case were all over the place, and the people being sued had to pay for the legal defense. So, counsel, I'm not easily distracted, but it's my understanding that the Attorney General provides attorneys for all of the departments just about in the state of Mississippi. But I would hope that an attorney would know where his allegiance lies, regardless of who paid him.